Councillor Sims, this is Chris Sebastian.
Good morning.
Oh, not so good. I, as you know, have a court date on the 7th. Since we have last spoken, which was around the last court date, I want to know if you have deemed yourself able to write a contract that does as I request, meeting my contractual requirements for a psychologist to go through the questions, not mental illness in any fashion, but simply the questions that deal with, am I competent to stand trial? I'm talking about the lawful questions that are found in D.C. law. Have you done that? Have you put together a contract that meets my requirements for a psychologist or psychiatrist to ask me questions on camcorder? Simple.
No.
All right. So you haven't done that. Now, be aware that Hunter has not in any fashion on any record, to my knowledge, acknowledged your signature on your motion to suppress evidence. I have on tape that you have made a statement saying that you told him that that's a real motion, that's really your signature, it really happened, government really got property, and then ignored all of that while I got kidnapped and tortured. I am speaking. Also, so you are aware, as you know, as I have told you before, and you said at that time, with my cousin Lynn present, nobody will believe what's on YouTube. But since that time, I have gotten a letter, just the other day in fact, from the Germans. You know I have a daughter who's a German and American citizen born in Washington, D.C. Do you not? Do you know this?
You've told me as such.
All right. Well, I've gotten a legal letter from the Germans that ask for all my net worth information. Now, you know, in your motion, you said government received property. I can't do an accurate net worth information while I'm embroiled in human trafficking and torture, theft by extortion under color of law. You do know what human trafficking, torture, and theft by extortion under color of law is in terms of the lawful definitions of such, since law is descriptive and prescriptive. Am I correct?
No.
You don't know that law is descriptive and prescriptive, or you don't know the definitions of torture or of theft by extortion under color of law?
You haven't defined it under state or federal law.
Well, theft by extortion under color of law is defined with documents that have been given to Hunter. He is not deemed to see fit to bring that information into court either. Though it is in front of the judge, as defined, there are 7 criterion for theft by extortion under color of law. I will be pleased to read them to you the next time. Now, that letter says that I have a deadline till the 1st of January. Today is after the 1st of January. I sent to the German embassy a letter, which I'm getting ready to get to the court, saying, I can't do net worth because I've got a scroll of silence, a 30-foot scroll that shows judges and lawyers lying on the record, shows intellectual property that went to government and elsewhere, and nobody wants to appraise it. I have asked for it to be appraised. I have filed many times with the DOJ trying to get this nightmare sorted out, but that scroll of silence is formally copyrighted, registered, tangible property. I have a video of paying the fee, and the property guy at the copyright office, the guy who takes, not the property guy, the guy who takes the forms and so on, says it is registered the second you pay. But I haven't gotten the inspector's report that was due about a year plus ago. And that's giving plenty of leeway. Why haven't I gotten the inspector's report? Because he's got to say that it shows judges and lawyers lying on the record and is a unique piece of tangible property, because basically it shows the destruction of the Constitution. Now, if I'm taking that tangible piece of property to the IRS, to their art panel, to get a report, they will say that it shows judges and lawyers lying on the record and that they can't evaluate it until it goes to a jury. It's like, graphic crime art you present to a jury. I've written the Germans, sent a certified letter saying such. I'm embroiled and mired in graft and corruption, theft by extortion, where people are trying a second assassination effort. Stuart? Are you there, Stuart?
I'm here.
All right. I have told the Germans that I am embroiled in a second assassination effort. People have lied in the first assassination effort from the get-go. Hunter has a lying, perjuring shrink report, as does the court now, that says the materials I showed her were dubious, but these are authentic public documents, which is why I was asking you to come into court and say, this is authentic public documents. These things happened. There is a Judge C.B. Day who did sign a warrant that was brought to him by Secret Service agent Hosey under the Bush administration, where they ignored all property and just tried to focus on threat. Indeed, they said the properties were delusional until they started coming out in Popular Science magazine, Scientific American. I have stuff, date, and timestamp. There is a DARPA. My cousin does know, both of them, that material went to DARPA. They both did the proof of principle, saying, one, cousin Lynn, the one you were with at the donut shop where you said nobody would believe what's on Facebook, he said it would have to be tweaked to work, and now it's working to the point that they're flying planes with their pilots doing nothing, landing on aircraft carriers. What about that property, Stuart? I have over 150 first prints spread out on my backyard that I took pictures of during a warmer time of the year. My yard is covered with crime art and parody art. What is that worth? That poster that I made for Hunter with your signature on it in large from your motion, and Judge C.B. Day's signature on it, and what theft by extortion is, and so on, I've got him on video trying to say that your signature is hearsay, while I'm handing him Rule 902 of the Federal Rules of Evidence, saying the public records are already authenticated. And 901 that say, if you're showing what it looks like you're showing, that's, what the evidence is that you're trying to portray. And there's nothing dubious about these evidences with other people's signatures on them. So I'm going into court where they have refused to honor my right to self-represent, withheld information, evidence. Trozman, the prosecutor, has withheld information. Hunter has withheld information. That information I jammed on them, and I've got it on transcript that I handed that poster, which is another piece of tangible property that nobody's going to be able to evaluate when I put the video of Hunter side by side with it, trying to say hearsay. We are talking about massive breach of law. And we're talking about drop-dead drugs, and if people have to lie to drug you, that's poison. Would you agree?
I have no opinion.
You have no opinion. Will you appear in court with me because you haven't been able to produce a contract, and in theory there's money for my hiring my psychiatrist under my contractual needs? Will you appear in court with me on the 7th to say that is your signature, to say the government got property, to say that the CJA rules, you know what the Criminal Justice Act is, do you not? Do you not?
I know what it is.
All right. In the Criminal Justice Act, it says they can't do any effort to goo your brains, play psychiatrist, send you St. Elizabeth's, any of that, until they've done net worth finding first. But everybody's declined to do that. I have on court transcripts that I get more money, $600 a week. That makes me ineligible to be represented by, basically, Hunter, who is in breach of every legal obligation to me and to my civil rights. And instead is playing assassin in collusion with Trozman, who has also refused to produce the Secret Service warrant, the acknowledged CB Day's signature on that Secret Service warrant, which happens to forget about intellectual property that government got. Started all of that. Nobody's wanted to look at Emden's lies, where he says, Bill Janot, psychiatrist, treated me, and Bennett, psychiatrist, treated me. But I've got their signatures on that scroll saying they didn't, along with Emden's signature and his motion, a public authenticated document, saying they did. More lies. So I've got this current perjuring shrink saying dubious to public documents I handed her, and I have that on video. So I have her altogether on video. I have Hunter saying your signature is hearsay. I have you not producing a psychiatrist that I can contract when the court has said I'm allowed to contract my own psychiatrist. And mind you, the only reason I agreed to that was because I had been picked up and I was in a cell just before the court date, because I didn't go from the previous judge who breached law and tried to get me into permanent housing. Yeah, in a nut house. She tried to, and she broke every rule, and they found that to be the case in the appeals court. This time, the appeals court didn't even want to bother, so they just wrote some gobbledygook. Can you tell me what sus sponte means? Stuart?
In what context?
Well, the order from the Court of Appeals says, blah, 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 outpatient competency examiners should not be dismissed for having been taken from a non-final order. Appellant's lodged response in the notice of appeal. It is ordered, sua sponte, that the clerk shall file appellant's lodged response. It is further ordered that the appeal is hereby dismissed as having been taken from a non-final order. But I want to know that the clerk shall file appellant's lodged response sua sponte. Does that mean that the appeals court files the appellant's lodged response sua sponte? Or does that mean it goes back to the superior court where the same lodged issues that they didn't discuss in the appeals court are in a motion to dismiss for obstruction of justice, for withholding evidence, for all kinds of things, all of which are grounds and cause for dismissal? Do I have to go put balloons in front of the court? I've already given the judge posters saying that by Rule Law 902, you've got to authenticate CB Day's signature. That also would be yours, but I decided I would spare you in that poster. Also saying, according to Criminal Justice Act, you've got to find net worth finding before anything else. These are my due process rights that people just deem that they can just forget about. I have a defense ready, Stuart, but people are refusing to look at that and trying to get a pseudo-shrink to say, oh, the documents I gave her were dubious. Well, I have them on tape, and I have our conversation on tape, and I have the Rule 902 that shows these are public documents. And then, which are authenticated. And then I've got on tape saying all that to Hunter. And he's trying to say, your signature is hearsay. While he's standing over a poster 4 feet by 5 feet that's got your signature in large on it. What do you say about that? Do you think that you can appear in court and put a stop to this travesty, Stuart?
I've sent you several recommendations.
I'm not interested in your recommendations that don't protect me. I'm happy to go see a psychiatrist with camcorder. I've got all the rules. I have sent in to the judge and to you on emails, half of which you can't seem to get.
People who do not have mental take camcorders to meet with a psychiatrist.
Yes, well, you know what? I do, because I've got judges and lawyers lying on that 30-foot scroll. Now, are you prepared to acknowledge in court that's your signature? I'm camcording this right now. Is that a yes or a no?
To what question?
Are you prepared to come into court and present your motion to suppress evidence that says government received property that my cousin knows about, and you stood by, and my cousin tweaked that property works? It would have to be tweaked. You want to look at the anti-graft laws that say that government's got no right to just take property?
The motion was never ruled upon.
I'm sorry?
The motion to suppress evidence had to do with the Montgomery County case, and that motion was never ruled upon by the court.
Oh, but it's still your signature, and you're not supposed to lie, are you? And I've got all the corroborating evidence to go with it. So whatever you want to say, however you want to whitewash or bury me, I'm not into being buried. Are you saying you lied in that motion, Stuart?
To the contrary.
All right, thank you very much. Are you going to appear with me in court? Are you going to provide me with a contract?
I will send you a recommendation.
I am not interested in a recommendation. I am interested in a contract where the questions that are asked formally, according to law, for competency really has nothing to do with any kind of mental illness whatsoever. It's just, am I competent to stand trial? And when I've got evidence I'm introducing into trial, and when I've got shrinks that say I've got a 99% reasoning IQ, and people are trying to lie and slander, and I can prove their lies and slanders through use of laws like this last little prevaricating shrink of Hunters and the courts, of DeMio's, who says, when I'm showing her public authenticated documents, and not just yours, Stuart, that now you're saying, well, let's start with Emden's, huh? Where he's lying in court, perjuring. And you're telling me that Hunter is not prepared to enter that information that shows prior bad acts, that shows theft by extortion? Are you telling me that I don't have the right to have my cousin Lynn and Rusty subpoenaed? Are you telling me that, Stuart? I don't have any right to defense or any right to introduce any evidence whatsoever. I just get gangland slammed away by worse than what the mafia would do. They kill you first and dissolve you in acid, Stuart. If I can show lie after lie after lie in court by people, and then they recant, which is what happened for 2.5 years in a horror situation, Stuart, are you not prepared to have me show that evidence that shows that the federal government, along with the state of Maryland, betrayed every rule of law, every constitutional principle, and there's property outstanding, and I have property now in my possession that people aren't... Where's the inspector's report? Do you want to stand by that scroll and go over it with me, Stuart? Today, tomorrow, Monday, Tuesday. We can go over Emden's signatures and CB Day's signatures and your signatures, and I can show laws side by side. I don't need a shrink to prove my case on camcorder. Will you stand with me and go over evidence that I can present you on camcorder, Stuart? Yes or no? There's time. You know, you want to see somebody lied about and have their brains savaged and gooed? Have you looked at the definition of torture, Stuart, that I've sent you? Stuart, are you there?
I'm here.
All right. Are you prepared to look over this material before we go see any shrink? On camcorder? You? Me? Is that a yes or a no, Stuart?
Again, I'll send you a suggestion.
All right, send me your suggestions. That's just more for the record. I've got a good record right now. Thank you.